Hey Space T fam, welcome back to my channel. So today I got two court hearings for you, one in Judge Simmons' court and one in Judge Ricky's court. The one in Judge Simmons' court is pretty interesting. The lady just can't keep her story straight. She's lying and the judge is like, wait a second, you just said this, now you're saying this. So it's just interesting to watch. And then in Judge Ricky's court, the guy pretty much fucked around and found out the hard way. I feel, in my opinion, the judge went light on him. Given the circumstances, but I know that if he comes back to court not doing any of the things that he is ordered to do, he would potentially be looking at more jail time. But that one too is kind of interesting. But before I get into the videos though, please like and subscribe, turn on the notification. That way you're notified anytime I post a court hearing. So without further ado, let's get into the video.
On the record in the matter, the people of the state of Michigan versus Paula Randall. I have here 22-01593.
Paula.
I also have 22-01594. Counsel appearance.
Assistant Public Defender John Lee appearing on behalf of Paula Jane Randall.
Okay, Ms. Randall, let's start with file number ending 593. I do have a misdemeanor complaint here that alleges that on or about April 10th, 2022 at the area of 6200 South Pennsylvania Avenue, City of Lansing, Ingham County, State of Michigan, that you did allegedly commit the act in count 1 of retail fraud in the 3rd degree, and that you did, while Myra was open to the public, steal property of the store that was offered for sale at a price less than $200, contrary to NCL 750.356D4. Count 1's a misdemeanor. The maximum penalty is 93 days in jail and or $500 in fines, or 3 times the value or difference in price of the property stolen, obtained, or attempted to be obtained, whichever is greater. File number 594. I also have a retail fraud 3rd degree, also at 6200 South Pennsylvania Avenue, for the date alleged to have occurred back on April 7th, 2022. Again, alleging that while Myra was open to the public, the defendant did steal property of the store that was offered for a sale at a price of less than $200. Again, a misdemeanor, maximum penalty 93 days and or $500 in fines, or 3 times the value or difference of the price stolen, obtained, or attempted to be obtained. Do you understand the charges read in both files and the maximum penalty?
Yes, I do, Your Honor.
You have the right to counsel. Mr. Lee from the Public Defender's Office is representing you today for the purposes of your arraignment, but you have the right to have an attorney represent you at each stage of the criminal prosecution, and the right to be represented by counsel if you are questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the Public Defender's Office represent you at the expense of the public. You understand that, right?
Yes, ma'am.
She's requesting court-appointed counsel. Mr. Lee?
Yes, she has, Your Honor.
Okay, Ms. Randall, you have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty, or you can stand mute. But if you stand mute, the matter will continue all the way to a jury trial. And you have the right to jury trial. You have the right to the presumption of innocence. You're innocent until proven guilty, and you have the right to require that the prosecution prove your guilt by proving each element of the charges being brought against you beyond a reasonable doubt. You can remain silent at trial and not have silence be used against you. You can subpoena witnesses to testify on your behalf at trial. You have the right to see, hear, or question in court any of the witnesses that the prosecution intends to call against you. And you can also waive your silence and testify at your own trial. Do you understand those rights?
Yes, ma'am.
The court's going to enter a plea of not guilty on your behalf at this time. Are you currently employed?
No, ma'am. I lost my in-home care patient 14 years last year.
What's your home address?
I have a mailing address.
What's that?
In Miss Lansing, Michigan, 48911.
Who lives there?
It's a gentleman I do housekeeping for.
Where do you live?
I'm in between places right now.
What's your phone number?
I have an emergency phone number, which is my fiance's, Alan Collins.
You are currently scheduled for a pre-trial conference before me, Judge Simmons. Your pre-trial on file number ending in 594 is March 24th, 10 o'clock in the morning. And the other file, same time, March 24th, 10 o'clock in the morning. Are you currently on probation or on parole?
Oh, ma'am.
Have you ever missed court in the past?
Only for, I got supposedly I had received a notice of failure to appear for another case, but I never received anything for that. That was for the court costs and fines for the assault and battery from back in 2000. That's the only one I know of.
You can address bond.
Thank you, Your Honor. We would ask the court to consider that Ms. Randall has lived here in the Lansing area since she was approximately 3 years old. She is engaged and intends to continue to reside here in the Lansing area. She reports that her only prior criminal offense was an assault and battery that she was just talking about in the year 2000, which is fairly dated. And based on that, we would ask the court to consider a personal recognizance bond on her behalf.
You mean the assault and battery from 2008?
If
You're talking about?
you would have
It might
better
have been from
record than I would, Your Honor. Like I say, 2000 is what she reported to me, but 2008 was probably more accurate.
Yeah, but she should remember it because it's in collections. Let's see
Agreed.
here. She has a collection here. She owes over $2,100 on this collection matter.
Okay. I can make an payment on that tomorrow afternoon of $40.
Okay, give me just a moment. This is
Yes,
from 2008. Looks like there was assault and battery. She pled no contest to.
I also did 25 days for that.
That's why I'm reviewing the file. Well, you did 25 days after the judge had to terminate your probation because you failed to comply. And then there's a 2013 file of identity theft. That probation was also terminated for failure to comply. So that explains why the collections is as high. It's more than one file. So you owe $2,101. You were supposed to be on a payment plan, but you've not made a payment, it looks like, since 2013. When are you gonna pay this?
I can pay a payment tomorrow afternoon for sure.
How much?
Of $40 is the most I can do. And then again, another payment on Sunday.
Are you employed? You say you're not employed.
Oh, ma'am, I donate twice a week.
Okay, so you're donating what, blood, plasma? What are you donating?
Plasma.
So you're
Plasma.
gonna make You're gonna make payments off the money that you're donating, getting
Yes,
from
ma'am.
donating,
Yes, ma'am.
but you don't
Every
have a
week.
house. But you don't have a house, you say you don't have a working phone. Let's see, and then did you turn yourself in on these warrants or were you picked up on something?
No, I was picked up at my fiance's building because we were going to be sleeping in the hallway, and a neighbor had called and made a complaint.
You can address Ron any further, counsel.
Thank you, Your Honor. In light of the recently shared information, we would ask the court to consider that she's definitely not a flight risk. She is working to survive right now, lost her full-time employment job and is looking for another one. And we just ask the court to consider that in setting bond.
I don't know that she'll be leaving the state of Michigan, and if that's what you mean, flight risk, but not returning to court is also considered flight. And if you know you got outstanding obligations and or pending actions, which these matters have been pending since 2022, and I have reason to believe she was aware of that. I don't know why she lost her employment a year ago, but I don't know how you're looking for a job and you don't know you have warrants.
Ma'am, I just lost my in-home care patient of 14 years last February. I donate twice a week. I am able to.
I understand that, but you lost your job a year ago?
Yes, I just recently lost my job.
Well, this is February, so it can't be last February and that's considered recent. Last February was a year ago.
Yes, I know that. He's been gone a year as of February 5th of this year.
Okay, so then that's not, you didn't lose your job last year and it's recent. If this was a year ago, what have you done in the last year to find work?
I did 14 years of in-home care service up until last year.
What have
Up
you
until
done?
past,
I didn't ask you that. What have you done in the last year to find a job?
I just recently lost my job. That's what I'm saying. I have not been able to go out and look for a job right now due to not having an address to use. I had a mailing address. I cannot use that mailing address because the gentleman's been sending my mail back. So I didn't know anything about the court hearings or anything from 2022 at all.
That's not what I asked. That's not what I'm asking you, because now you're telling me that you can't get a job. You can't get a job because you don't have an address?
It's not that I can't get a job. I have not been able to go out to look for one due to I have walking pneumonia. I just found out I have walking pneumonia. I have not been able to go out to look for a job, another job, because I'm in the process of getting my new documents like my ID, my social security card, my birth certificate. Due to moving, I've lost all that information, Your Honor.
Right, but this has been a year that you say you lost your job. What have you done in that last year to be in the process of doing those things?
Going through all the agencies that I can to get the information that I'm needing so I can look for a place.
Which agencies? Which agencies?
DHS, my former worker at the Advent House. I'm trying to get in contact with her to get my documentation that she has on file so I can find another job and find another place to live at. Me and my fiance are also in the process of trying to find something for us to move to because we can no longer be at his aunt's house.
Who was your contact at Advent House? What's their name?
Ty. I do not know her last name.
Ty?
Yes, ma'am.
How are you been trying to get in contact with Ty?
I've been calling the Advent House to get her number. They have not been able to relieve it to me yet. They have not spoke to her yet. I do have her information somewhere in some of my belongings that's still at my fiance's aunt's apartment. I was residing with my.
If I told you that Ty has not worked at Advent House in over a year, would that surprise you?
No, it will not.
But why, if you contacted Advent House, why wouldn't they have told you that?
They have told me that she doesn't work there. She works from home. They do have her cell number, but they have to locate the cell number.
Okay. A bond in file number 1593 is set in the amount of 200 cash surety. A bond in file number ended in 594 also set in the amount of 200 cash surety. While out on bond, you have the following conditions. You must report to all of your future court dates. You are not to use, purchase, or possess drugs or alcohol without a valid prescription. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to travel outside the state without prior approval of the court, and you're not to be at the area of 6200 South Pennsylvania. That's bond conditions on both files, okay?
Yes, ma'am.
Okay, and then we'll have the matter for your collections set out for a show cause on the date of your pretrial so that we can address that at that time, okay?
All right.
You do need to get back on a payment plan, but I don't think that you need to donate plasma to do that. I think you need to get a job to do that. So
Well,
we'll address that at another time.
But I can, like I said, I will make a payment tomorrow for sure.
Okay, any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
You're all set, sir. Ma'am.
Twenty 2023 CR 82. James Watts appears as defense counsel. Amber Norris on behalf of the state of Kansas. Jordan Dillon appears from a court security Zoom location at the Butler County Judicial Center. Before the court is a warrant to show cause alleging probation violation, including failing to obtain full-time employment as directed, positive urine samples, failed to re-engage in substance abuse treatment as directed by his ISO. Mr. Watts, what are your client's intentions regarding these allegations?
Thank you, Your Honor. As to the first allegation that failed to obtain full-time employment, my client would acknowledge at the time of his arrest on this warrant to show cause, or at least at the time of the issuance of the warrant to show cause, he did not have full-time employment. I will note for the record, my client tells me he is now working at Spangles, in fact, has work tomorrow. So that has changed. As to the second allegation, submitted positive urine samples on a number of dates, he would agree with that and stipulate to that violation. And as to number three, failed to re-engage in substance abuse treatment, he would acknowledge that at the time of the issuance of the warrant, that was correct. He would stipulate to that violation, would tell the court he is now, and it's my understanding Mr. Ketley is aware of as well, is now back in a treatment program.
All right. All right, Mr. Dillon, you do have a right to a due process hearing where the state would have the obligation of proving these allegations by a preponderance of the evidence. You can challenge the state's evidence, present your own evidence, confront the state's witnesses unless good cause was shown, and among other lesser remedies, the court could consider an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things?
Yes, Your Honor.
And do you waive a hearing and stipulate and agree that you committed the violations as qualified by your attorney, no doubt, as to 1, 2, and 3 of the warrant to show cause?
Yes, Your Honor.
All right. Court finds that the defendant has waived a formal hearing on the allegations, stipulates and agrees that he committed the violations as alleged. Mr. Ketley, can you confirm that the defendant has re-engaged in a substance abuse treatment program at this point?
Yes, Your Honor. On 3/11, he met with Higher Ground and they went back over his evaluation and reinstated him into treatment.
Very well. Has he provided any verification of being employed?
No, but when I met with him when he was taken into custody, he mentioned he was working at Sonic, and I even spoke with his grandma, and his grandma had admitted it or had stated that he was working at Spangles also in Andover.
Okay. All right. Do you have recommendations at this time, Mr. Ketley?
Well, Your Honor, we've had, I was kind of hoping it wouldn't have got to this point. We've already had 2 sanctions for roughly the same type of stuff, using marijuana. And Sedgwick County said that until we have a little bit harsher sanction, then they sent him back, but they will take him back if it gets to that point.
All right. What are the state's recommendations here, Ms. Norris?
Your Honor, state be recommending 30 days in the county jail. This is defendant's second warrant to show cause. And in the interim, since the previous show cause, which was in June, the defendant has had both a 2-day dip and a 3-day dip that he agreed to voluntarily with his ISO, both of which had to do with him not getting back into treatment. So that has been a consistent problem since the last warrant to show cause. So we would ask 30 days in the county jail that he complete get into and complete drug and alcohol treatment. And Your Honor, he would need a 12-month extension. I believe at his last show cause in June, he was extended 12 months on June 21st, but to avoid him not being able to complete treatment within the allotted time, state would ask for a 12-month extension from today's date. And the court will need to address court-appointed attorney's fees as Mr. Watts has been reappointed.
Mr. Watts, your recommendations regarding an appropriate disposition.
Well, Your Honor, I will note, as I mentioned earlier, Mr. Dillon didn't hesitate to acknowledge where he'd failed here. He didn't try to deny any urine samples. There are a couple of things that has changed. A, he has work. In fact, I understand he has work tomorrow at, you said $18 an hour? Is that correct?
It's $12 an hour.
$12 an hour. Okay. So he has work tomorrow, and he desperately wants to go back to that. There's one other thing that's changed. Mr. Dillon tells me he has now as a child, born sometime last month. I don't know the exact date, born in February. And perhaps most important, first thing I asked him when we came on is, if you tested today, would he be clean? And the answer was yes. He was in jail from February 14, according to Mr. Dillon, arrested on the 14th, out March 3rd. So he's had about 17 days in custody. Since March 3rd, we're now at the 14th, not quite 2 weeks. He tells me he is clean. Again, I've not tested him. I have no way to do that. But if that's the case, we're making progress. He has work. He has, at this point, back into treatment program, and he has a child now to take care of. And he spent 17 days in county jail. So, Judge, what I'd like to say is that the time that he served should take care of that sanction and should get his attention. 17 days rather than a 2 or 3 day dip. If the court believes it is necessary to impose further sanction, I would encourage the court to schedule that time so he can continue to attend his job and continue to work.
How much are your fees in the representation of the client on this round of proceedings?
Judge, we're billed for $880 at a show cause.
All right. Mr. Dillon, I'll address you personally, and I'll ask you, do you have any statements that you wish to make in mitigation of punishment here, or anything further that you would like to present to the court?
No, Your Honor.
You just had a child born to this world?
Yes, he was born February 25th. And
His name?
his mom's in the hospital right now. So with
What's the child's
schizophrenic.
name?
Leonidas.
And I trust he has a last name?
Yeah.
Dillon?
Last name? Yeah, Dylan. Yeah.
Oh, okay. It wasn't a good question.
Sorry.
All right. And you're saying the mother is in the hospital right now? So who's providing care as we speak?
Me and her grandpa, or his grandpa, excuse me. He's a little guy. He was born a month early.
He's off to a rough start, obviously.
Yeah, well, his mom, she's not the best. So
Well, Mr. Dillon, why are you taking chances when you've got a child to take care of? I don't
I,
understand why you're just not doing what you're supposed to be doing. You can stay in the community. You can be on probation. You can take care of your child. If you do what you're supposed to do, you don't have to serve time in jail. But unfortunately, your track record is you just can't consistently do what you're supposed to do.
well, that me serving that time has really woke me up. I'm gonna be honest with you. That and having not being there for him when he was born, that really hurt me. I understand that I have messed up, and I am making an effort to make it right. I promise you that. And all my fines are paid off. Well, of course, I'm gonna have more, but from previous, everything's been paid off.
You like marijuana?
No. I did, but not now. I've learned my lesson. I do not want to go to jail. I've learned my lesson. Trust me. I like I told him I would be clean today if I do a UA. I have not used. Like I said, I'm back in treatment. I'm making an effort for my son and for me.
You have a lot to be on probation for, Mr. Dillon. You're just about ready to blow it.
I know that, Your Honor.
All right. First of all, the court's going to take into account that Mr. Dillon has served 17 days in jail in regards to this warrant to show cause. The court, while believing at least on its face that the state's recommendation is sound, the court's not going to order the 30 days of sanction time, which was suggested in this case, rather recognizing that Mr. Dillon has taken some corrective steps regarding the allegations which are currently before the court. The court at this time will take into account the 17 days previously served, but there must be a prospective sanction here. Mr. Dillon, in some ways, I'd really like to make this hurt so that you sit in jail and you wonder what in life you're giving up. And I'm not necessarily wanting to interfere with a job that you've just started, but I'm going to order you into custody immediately to serve an additional 48 hours in jail, starting immediately. While a court could make that a much, much longer sanction, and perhaps under these circumstances it should, again, taking into account that it's already cost you 17 days of your life on this round, and the deprivation from your young child who probably needs you right now, but apparently, at least at one point here, relatively recently, marijuana was more important to you than any of that.
Yeah,
You need to break yourself from that, Mr. Dillon.
I have, Your Honor.
Your son's counting on you to do that.
I have. I promise you that.
All right. Mr. Kentley, at the first in-person meeting after he is reinstated onto your probation, in other words, as soon as he gets out of this 48-hour sanction period, he's reinstated on community corrections and extended through December 31 of 2025. He needs to satisfy any condition that hasn't been previously satisfied, including a proper re-engagement and completion of a substance abuse treatment program and any aftercare recommendations. But at that very first meeting, Mr. Ketley, I'm going to order that he be UA'd. I know you're probably just as interested as the court is. Is he telling the court the truth that he's going to be clean on a UA right now? I wonder. I hope so. Dylan, I have every reason to believe you, but we're going to check that out.
I just did a UA for my treatment, so.
Well, I'm going to want Mr. Ketley to do another one.
Okay.
You and marijuana are permanently divorced, Mr. Dillon.
I know that, Your Honor. Trust me.
Okay. All right. I've extended probation through the end of this year. Ms. Norris, I need to address further assessments in the case. Because you messed up again, Mr. Dillon, I really should hit you with some additional bids costs in this case. I'd rather see you spend this money on your son and his care.
I appreciate that, Your Honor.
He needs to be the recipient of the funds that you earn to some extent. So I'm not going to assess any additional bids amounts at this point. I'm ordering Mr. Dillon into custody to serve 48 hours sanction time effective immediately. With that re-pronouncement, Ms. Norris, is there anything else we need to address?
Your Honor, what was the day in December of 2025 for completion?
I am extending him through December 31 of 2025.
31. Okay. Thank you, Your Honor. Nothing further, I don't think.
All right. Mr. Ketley, do you have any questions or any further clarification needed?
No, just Dylan, I need to call me first thing Monday morning and let me know when you can come in.
Yes, sir.
And when you get to jail, call your job too.
Okay.
All right, Mr. Watts, anything further that the court needs to address currently?
No, sir, thank you.
Very well. Then the Jordan Dillon matter will currently be in recess.